to the question of birthright citizenship. We just had a very interesting discussion about it on Laid Back News, and I think it was Joe who mentioned there was this law review, which is the academic publications for lawyers that reviewed this comment or subject. And I thought maybe we could read it, or at least read some of it. I'm not promising to read all of it. It's 75 pages. But we could read at least some of it and see if it can refine some of our thinking on this question of birthright citizenship and exactly what is the law in the United States. So I thought we could read this. We can start with the abstract. This is written by Amy Swearer. Who is Amy, incidentally? We'll give her bona fides. She is unclear, legal policy analyst at the Center for Judicial Studies. So I think she is a law professor at the College of Law, legal policy analyst. I think she's a law professor, but not clear. Maybe it's something like that. Anyways, so Amy here has some thoughts on the subject, so we're going to read Amy's thoughts on the subject. Scholars today generally presume that all individuals born on United States soil are United States citizens under a theory that the 14th Amendment mandates a universal birthright citizenship in the nature of the English common law jus soli. While it's indeed clear the Constitution recognized citizenship as a birthright of certain U.S.-born individuals, both textualist and originalist analysis of the citizenship clause substantially undermine assertions that birthright citizenship must be applied universally to all persons born in the U.S. soil, regardless of immigration status of the parents. The framers of the 14th Amendment had a distinct understanding of the citizenship clause jurisdictional element that's incompatible with true jus soli. The clause's purpose was to ensure there would no longer exist in the United States a class of persons regulated to perpetual non-citizen status on the basis of race, despite not owing allegiance to any foreign or tribal power. This more limited application of birthright citizenship was adopted by the earliest commentators on and Supreme Court's assessments of the amendment. Supreme Court precedent itself extends only to the premise that U.S.-born citizens of lawfully present permanent domiciled aliens are citizens. I mean, that's true insofar as it goes. That is what the Supreme Court precedent says. So that much is true. This premise is consistent with the Amendment's purpose of foreclosing the possibility the United States would create generations of permanent resident non-citizens who nevertheless owe permanent or undivided allegiance to the United States. To the extent the Supreme Court appears to have adopted common law jus soli, the American jus soli must be understood as less rigid version than the English counterpart, reformed to make it consistent with the American purpose and scope. This indeed appears to have been the court's intent with its principal decision regarding birthright citizenship in the United States versus Wong Kim Ark. Finally, while the United States naturalization law no longer risks the creation of lawful resident classes held perpetually in non-citizen status, immigrant aliens, unlike illegal or non-immigrant aliens, are subject to complete jurisdiction of the United States for the purpose of birthright citizenship. Okay. So that's their conclusion. Let's see where we want to start with this. I think we'll just probably read part 1 here, textualist and originalist understanding. Yeah, I think we can skip the precedent for the moment, and I think we'll stick to the historical issues for the moment. I think that makes the most sense. So I think we're going to read these 26 pages and see what it has to provide us. I think is what we're going to do. All right. President Donald Trump has brought to the forefront of the American consciousness a conversation that has long been brewing beneath the surface among certain scholars, namely where the 14th Amendment citizenship clause mandates that all persons born on U.S. soil are U.S. citizens regardless of immigration status of their parents. This heretofore largely unquestioned premise is known colloquially as universal birthright citizenship and has been the policy of the United States government for over a century, even as some scholars and politicians have made waves in asserting the policy is unnecessary under the 14th Amendment and incentivizes unlawful immigration. Calls to restrict the granting of birthright citizenship so as to exclude the children of illegal or non-permanent resident aliens have taken on a new force in recent decades, and the growing cost of illegal immigration has continued to weigh heavily on taxpayers. The explosive rise of birth tourism industry has only further heightened scrutiny over the practices of universal birthright citizenship. Capitalizing on these concerns at various times in lead up to the 2016 presidential election, by the way, this was written in 2020, so, bear that in mind. This was written in 2020, so obviously I can't discuss anything that's happened since then. Capitalizing on these concerns at various times in lead up to the 2016 presidential election, then candidate Trump publicly questioned whether the 14th Amendment mandated universal birthright citizenship and pledged as part of his first immigration reform plan to end the practice of automatically treating citizens as U.S.-born citizens. In 2018, during the second year of office, President Trump again raised the possibility of limiting the application of birthright citizenship via executive order. And then, of course, 4 years later, he'd actually do it. This article analyzes the legislative and legal history of the 14th Amendment. Okay, we're going to skip the rest of this introduction. Although the precise meaning of textualism and originalism is up for debate, fair, no analysis of the citizenship clause under any general understanding of these interpretive theories can support the claim of mandated universal birthright citizenship. From the very structure of the text itself, it's clear that more is necessary for birthright citizenship than mere birth on the U.S. soil. Well, yes, we do understand it says subject to jurisdiction thereof, but, let's move on. Further, the history, context, and purpose of the 14th Amendment indicates the citizenship clause jurisdictional element served a unique purpose in not just granting citizenship to newly freed slaves, but of withholding it from those who are not similarly situated to freedmen in terms of allegiance owed to the United States. The view to the clause's original public meaning is not supported only by the legislative history, but also in the writing of contemporary scholarship. Okay. A well-established doctrine of legal interpretation posits that legal texts, whether statutes, regulations, or constitution, should be read with a presumption against redundancy. Yeah, we do try to avoid surplus, as we would say. Words mean something, and we do try to avoid the words not meaning something because we say they're surplus. So surplus, the idea of interpreting words as surplusage is to be avoided. Unless this reading would lead to absurd results. Yeah, we do try to avoid it. It's not always possible. Indeed, this interpretive canon is deeply embedded in the American jurisprudence and intertwined with the belief that Congress does not use words or clauses that have no meaning. Congress presumably meant something when it wrote it. As Chief Justice John Marshall explained in the bedrock case of Marbury versus Madison, it cannot be presumed that any clause in the Constitution or statute or regulation or whatever is intended to be without effect, and therefore such a construction is inadmissible unless the words require it. Put another word, every word or phrase of a section of legal text adds something. Fair? Under both the statutory and principle of interpretation and the most natural reading of the 14th Amendment, the citizenship clause indicates that more is required than birthright citizenship than mere fact within geographical. Yes, we all know that. It says subject to the jurisdiction thereof. I don't like this introduction because it's like, we all know that. We all know it says subject to the jurisdiction thereof. So it must mean something. The question is, what does it mean? It's like, yes, we all know it says it. Get to the point. The clause reads, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the states in where they reside. The phrase subject to the jurisdiction thereof, thank God we're finally going to get to the point, is an additional qualification on the preceding phrase born in the United States. I agree. And there's the application of citizenship to a subset. I agree. To be subject to the jurisdiction then must logically mean something more than being born in the United States. I agree. That the citizenship clause jurisdiction requirement is more than a reiteration of geographic location is supported by the fact that jurisdictional requirement was a later addition to the language. When Senator Benjamin Wade from Ohio first proposed adding a definition of citizenship to the proposed amendment, the initial wording was simply all persons born in the United States are naturalized by the laws thereof. Interesting, like it's interesting to go through constitutional text and how it's been modified in the process of becoming constitutional text. That was like one of the major papers I wrote in law school, was a historical review of the Second Amendment. And I went through every version of what would be the Second Amendment through every proposal as part of that. It's interesting when you kind of look at, what the language was at various drafts, along the way. It's kind of cool. And much like that, the 14th Amendment also went through some drafts. It had a couple of revisions. 1 week later, Senator Jacob Howard responded by introducing a revised definition that included the jurisdictional element in addition to the geographic element. It was this second definition, revised specifically to include and subject to jurisdiction thereof, that was adopted in the final version of the 14th Amendment. The Second Amendment went through more than 2 drafts. It went through like 6 or 7 drafts. But apparently with the 14th Amendment, we got it right in 2. That's nice. Yeah. Birthrights are inalienable. In fact, since handed by creator, are they not? It depends what you mean. Do you mean human rights? If you mean human rights, then human rights are inalienable. I would agree with that. So there's certain fundamental rights that are self-evident, then sure, that's the Declaration of Independence. It's like, that makes sense. But this alone does not provide enough information from which to form a conclusion about who exactly is subject to the jurisdiction of the United States for the purpose of citizenship. Advocates of universal birthright citizenship have long maintained the phrase merely adopts the English common law exclusion of ambassadors and accredited foreign diplomats, plus, soldiers here on a foreign war, plus Native Americans. The Native American thing actually is probably the best argument for Donald Trump's EO, or if not the EO itself, the more generalized conception, right? So we can blow past the EO and just go to like sort of the fundamental point, which is who are citizens, right? So to the extent the EO is making an argument, right, we can reflect on the broader principle. And the fact that Native Americans were not deemed to be within the 14th Amendment is a pretty good argument for Donald Trump, because Native Americans were undoubtedly born on the soil. They were born on the soil for the last 20,000 years, right? But they weren't considered natural born citizens, despite being born on the soil for 20,000 years. So it's got to be more, and that was true, incidentally, regardless of where they were born. That would be true regardless of whether they were born within their tribal lands or not. If they were visiting New York, that would still be the case. So, yeah. Let's see, where were we? All right, pressing on. Given the dominant understanding of diplomatic relations in the 19th century, however, it's unlikely on its face that the jurisdictional limit was added solely to eliminate from birthright citizenship the children of ambassadors and foreign diplomats. The most prevalent theory of diplomatic immunity at the time was based on the legal fiction of extraterritoriality, wherein ambassadors and diplomats, though literally present on the United States soil, were still considered to be living in the sending state, with the diplomat's person and mission comprising an extension of the sending state's territory. This is not my understanding of the concept of diplomatic immunity today. American Samoans don't receive birthright citizenship. I think that's a stronger argument. It gets more complicated with the territories for a lot of legal reasons that we don't need to go into. So I don't think it's a strong case, but it's obviously worthy of being noted in there that, it's obviously the territory of the United States. And so, but, it's a little different than being born in the state. But fair point. As the New York Superior Court stated in as I was saying, I interrupted my own train of thought. To the best of my understanding, this is not the agreed upon legal principle for diplomats today. It would be a mistake to, as far as I would understand, it would be a mistake, for example, to say an embassy is located within the soil of that country. Right. So it is not, it would be a mistake to say, for example, the Cuban embassy in DC is located on Cuban soil by virtue of being the Cuban embassy. Right. The fact that diplomatic immunity applies and the U.S. can't, go into the consulate does not preclude it from being U.S. soil. And like one of the ways that you know that, for example, is because the United States can, and in fact, with respect to Cuba in particular, has in the past expelled the entire embassy and be like, you don't get to be an embassy anymore. Right? It's like you don't get to be here. So it can't be the foreign soil, because if it were the foreign soil, we wouldn't be able to do that, right? So I think this is not the understanding today. I think this is an incorrect statement of how diplomatic immunity is viewed today. As a New York Superior Court stated in 1889, the rule of international law derives support from the legal fiction that an ambassador is not an inhabitant of the country to where he's accredited. Well, I don't know. That's a legal fiction. I mean, you can be present somewhere and not be an inhabitant of that place, even if you live there for long periods of time. But of the country of origin, and whose sovereignty he represents within the territory he, in contemplation of law, always abides. Yeah, that's a weird framing. It's a weird framing. Like, under the ambassador's feet perpetually is his own country. So it's a very weird framing. That would lead to some very interesting legal consequences, incidentally. In other words, the geographic restriction alone would suffice to exclude the children of foreign ambassadors who would not have been considered born within the United States in the first place. Interesting. So if you go back in time, in older international law, they would not be considered to be within the soil of the United States, despite the fact they're standing in the middle of Times Square. That's an interesting conception, right? That's an interesting way of phrasing it, or thinking about it. It's like, despite the fact that the ambassador is standing in the middle of Times Square, he's not standing inside the United States. That's a very weird way of framing it. But, if that's the original conception, then okay. That's a strange way of putting it. To my mind, at least, it's very strange. But the necessity support for this conclusion must be reached by turning outside the text and in the immediate framework. A deeper dive into history, context, and purpose of the 14th Amendment sheds light on the original meaning of the Citizenship Clause jurisdictional element. While there are certainly different ways to determine a document's original meaning, there can be little doubt that the subjective understanding of the document's framing help inform the determination of the word's legal meaning. To some degree, it's not my favorite tool in the world, because you're using like history in the same way you wouldn't use statutory history, like you wouldn't use speeches in Congress to interpret a bill. Yeah, that's not really one of my favorite tools. Yeah. In fact, as the Supreme Court has noted within the Citizenship Clause in particular, while subjective intent of congressmen is not controlling of the question, the statements of congressmen are valuable as to contemporaneous opinions of the jurist and status upon the legal meanings of the words themselves. What then do we find in the debates over the language of the Citizenship Clause? And how does debates context help inform our understanding of those debates? In short, we find that the men who drafted and ratified the amendment had a very specific understanding of the language and a very specific purpose for that language. Namely, they believed the amendment was largely an effort to make citizens of newly freed slaves, that citizenship, however derived, ought not to be applied differently to similarly situated individuals on the basis of race, and those born within divided allegiances were not subject to the jurisdiction of the United States. Interesting. There is a near universal concept that the primary, if not sole purpose of the 14th Amendment Citizenship Clause was to authoritatively overrule the Supreme Court's holding in Dred Scott. Yeah, I mean, correct. Although I think, strictly speaking, overrule is the wrong word. I think the correct word is vacate. I need to take a phone call, guys. I'll be right back, okay? I apologize, chat. My mom is in the hospital. She has unchecked blood pressure issues, and I don't want to think about that right now. So I'm going to go back to doing some legal analysis now for a while. Yeah, pressing on. Yeah. Okay. Yeah, so this has been an issue for her for the past couple months, and she's been to multiple doctors, including multiple specialists, and they can't treat it. And so, yeah, or at least none of the treatments have been effective. Pressing on. Where were we? Okay. The court determined the U.S.-born descendants of African slaves were not citizens with the meaning of the term as used by Article 3 of the Constitution and could never become naturalized citizens, even if freed from bondage and made citizens of a particular state. The Dred Scott majority reasoned that individuals of Black African descent were members of an inferior racial order who were not considered members of the American political body at the time the Constitution was adopted. In so many words, the majority concluded that the United States was created by the descendants of Europeans for their posterity and their posterity alone. Not only that, but the descendants of Black Africans were so far, this is again quoting from Dred Scott, by the way, just in case, the language is very charged here. So this is Dred Scott's language. Not only that, but the descendants of Black Africans were so far inferior to the descendants of Europeans, they had no rights with which the white man was bound to respect, and then the Negro might be justly and lawfully be reduced to slavery for his benefit. Great. That's yeah. The decision, in the words of the famed abolitionist Robert, it's been a while since I've read Dred Scott. It's like, holy shit, dude. It's like that's some spicy language, man. Holy shit. Such a bad case. Yeah, really bad case. Yeah. The decision, in the words of the famed abolitionist Robert Purvis, confirmed that the United States government would continue the view that colored people are nothing but an alien, disenfranchised and degraded class. It was this judicial holding and the result of that the framers and founders of the 14th Amendment sought to void through the legislative branch. Of course, overruling Dred Scott was but one of several major purposes of the amendment as a whole. And incidentally, for whatever it's worth, of course, the 14th Amendment is the thing that incorporates the Bill of Rights against the United States. So it's the reason that your state also can't, can't infringe your First Amendment rights, right? Without the 14th Amendment, the state of Texas could have an official religion. The state of Utah could have an official religion. I wonder what religion the state of Utah might choose. So hard to tell. But, it's like the 14th Amendment is also the thing that prevents the states from doing that. You like that picture of the little black girl? I like that too. Yeah, that's a famous one. It's under my, it's under the thing right now. But that's Norman Rockwell. I believe that's called The Times We All Live In. I can't ever quite remember the name of it, The Times We All Live In. And that depicts a real event. That depicts, I forget her last name. Her name is Ruby, the girl. I forget her last name, but it depicts a real event. Ruby being taken to the schools by the marshals as the schools are being integrated in New Orleans. So I always like that. I find it very hopeful. I find it very inspirational. I find it a painting of hope, and I find it a painting of I find it very cathartic. It's definitely one of my favorites. Thank you. Ruby Bridges. Yeah, that's the right one. I just can never quite remember her last name. Anyways, pressing on. The question of citizenship for newly freed slaves was but one aspect of the general and much more basic concern for the systematic denial of civil rights to freed slaves and Union supporters in the former Confederate States after the Civil War. The Joint Committee of the Reconstruction in-depth report on social, political, and legal conditions in the southern states includes graphic firsthand accounts of the horrific treatment of former slaves, including forcible attempts to effectively re-enslave and random unprovoked killings. Yeah, I mean, for those of you unaware, the U.S. history is not exactly great on this issue, although to be slightly fair to the United States, neither is the rest of the world. And this is one area where I think some of our more left-hand brethren sometimes miss the plot because they will accuse U.S. of having like some unique evil in this domain. And unfortunately, not so much. Although the United States was in, the world is built with blood. The history of slavery in the world is not a fun and exciting story. Yeah. So things were pretty fucked up for a while. Let's move on. In a much more immediate sense, the purpose of the 14th Amendment was to constitutionalize the piece of legislation through which Congress first attempted to rectify the moral atrocity of Dred Scott and protect the civil rights of freed slaves, the Civil Rights Act of 1866, which had been passed earlier that year by the same Congress over President Andrew Johnson's veto. I forgot about that. This legislation was intended both to enforce the provisions of the newly ratified 13th Amendment and ensure the newly freed slaves would receive the equal protection of the laws, even in states that would rather strip them of any meaningful rights. And then we never had any problems ever again with any of the states trying to deprive people on the basis of race. Oh, Lord. It also statutorily defined for the first time in United States history the parameters of birthright citizenship. All persons born in the United States and not subject to any foreign power, excluding Indians not taxed, or hereby declared to be citizens of the United States. This is from the Civil Rights Act of 1866, I believe. Yep, it is. That the 14th Amendment was drafted and passed in order to place the provisions and protections of the Civil Rights Act beyond the ability of a future Congress to easily repeal it is evidence from clear legislative intent. Well, I mean, that's how serious Congress was, I guess. That's just how serious Congress is. Congress apparently was like, you know what? We think that slavery is bad. And we think that there should be a Civil Rights Act that says, discrimination on the basis of race is bad. And the president of the United States was like, no, I don't think so. I don't think we should have that. And Congress is like, not only are we going to override your veto, not only are we going to override your veto by 2/3 in each house and make it the law anyway, but we're so pissed that we're going to make it part of the Constitution. Just that's how pissed we are. So, go Congress, go. There were at times of the civil rights passage doubts by even some of its proponents as to its constitutionality. Well, we solved that problem right up, right? We're not sure whether the Civil Rights Act is constitutional. You know what will make it constitutional? We put it in the Constitution. That solves that problem right up. These doubts were serious enough to cause President Johnson to exercise his veto power, at least in part, because he believed Congress lacked the constitutional authority to displace state laws that discriminate on the basis of race, to place limits on how the states could legislate under general police power or subjugate the state judiciary to federal law. And, fair enough. Fair enough. Those are some really legitimate concerns. You know what will solve that problem? How about a constitutional amendment? Constitutional amendment will solve those problems right up. Congress ultimately override the veto, but it was clear to many in the Republican majority the constitutional amendment would be needed to give the Civil Rights Act a solid foundation on which to survive future legal challenges. In this context, the Joint Committee on Reconstruction took the tack of drafting what would become the 14th Amendment. Thank you, not a band account, for your nice super chat. In this context, the Joint Committee, the connections between Dred Scott, the Civil Rights Act, and the new amendment were repeatedly and clearly drawn throughout the congressional debates, perhaps nowhere as clearly as by Representative George Miller in his 1867 speech before the House regarding the amendment, wherein Representative George Miller said the following. The first section thereof makes all persons born or naturalized in the United States and subject to the jurisdiction thereof citizens, and also prohibits any state from making or enforcing any law which shall abridge the rights of citizens. I liked that clause too. I liked the privileges or immunities clause too. It would be nice if we could unnuke it. I missed that one. This, in effect, ingratiated in grafting the Civil Rights Bill and affording to all adequate protection, which is so just I cannot see how any objection can be seriously interposed, unless it's by those whose consciousnesses have been seared with rebel doctrine that a Negro has no rights to which a white man is bound to respect. Basically saying, unless you agree with the Supreme Court in that stupid decision, I don't see how you can possibly agree with it. So you know what I'd like to do? I'd like to overrule the Supreme Court. That sounds fun. The connection and context are necessary to help inform us of the meaning of the clause. All right, so now we're going to get into a little bit more about jurisdiction elements. What is jurisdiction? Now, it's certainly possible that the same legal word can have multiple different meanings. We're not beyond that possibility. So, and jurisdiction, incidentally, by that way, like if you're saying jurisdiction, there are a couple of different kinds of jurisdiction. We talk about personal jurisdiction sometimes. We talk about subject matter jurisdiction sometimes. There's probably some other jurisdictions I'm not remembering off the top of my head. But like the concept of jurisdiction, like there can be multiple different kinds of jurisdiction. So, let's figure out what we meant by jurisdiction, I guess. Some proponents of universal birthright citizenship have argued the citizenship clause does not distinguish between the immigrant status of the U.S.-born parents. They insist that children born to alien parents, which is anyone who is not an American, are subject to the jurisdiction of the United States because, like children born to citizen parents, they must obey the U.S. law, pay taxes on income, and can be removed from their homes by government officials, or prosecuted for crimes, or sent to jail and stuff, right? So they're subject to the jurisdiction because, all those reasons. And if you had asked me a week ago, that's what I would have said. So, we'll find out whether or not they're going to change my mind, I guess. In support of this, some legal commentators have argued the 14th Amendment drew on pre-existing legal terminology when drafting the citizenship clause, and that antebellum discourse and legal sources routinely demonstrate the term jurisdiction originally meant mere sovereign authority. In other words, these proponents assert that to be subject to the jurisdiction of the United States is a very bare bones requirement, depending upon factors as to whether the individual is, in the moment, subject to certain U.S. laws or taxes, or otherwise liable to the United States sovereign authority in any basic sense, such that the United States government can lawfully exert control over the individual. So jurisdiction here means, can I, for example, prosecute you? Can I, for example, arrest you? Can I, for example, sentence you to jail? Can I do those things? That's what jurisdiction means. That's definitely one way of understanding the term. This construal of the citizenship clause jurisdictional element is fundamentally flawed, not only because it violates the interpretive rule against redundancy. Virtually every individual present on U.S. soil is in some way subject to a basic level of sovereign authority the United States government exerts under its geographical authority, including individuals whose exclusion from birthright citizenship is uncontested. This is an interesting argument. Right? If you view it that way, it becomes a redundancy. We don't like redundancies, so you shouldn't view it that way. Okay. But it also fails to account for the very clear understanding that the amendment framers and ratifiers had of two different degrees to which a person could be subject to a country's jurisdiction. The first degree of subjection to a country's jurisdiction was, indeed, correlated with subjugation to the country's mere sovereign authority, and should not be the least bit unusual to find the United States courts most typically refer to this most basic level of jurisdiction. But it's clear that men who drafted and passed the citizenship clause also recognize a second degree of subjugation to a country's jurisdiction, a subjugation to its complete jurisdiction in a way more closely associated with the rights, duty, and deeply rooted national allegiance inherent to long-term residence in and meaningful interactions with a particular society. This understanding of complete jurisdiction and allegiance, as opposed to a lesser degree of jurisdiction and allegiance, is evident throughout the debate over language defining citizenship in both the Civil Rights Act and 14th Amendment. Congress expressly considered this distinction and intentionally framed the way of citizenship in a way that contemporary legal scholars understood as referencing only the higher level complete jurisdiction. Well, if that's true, one wonders why they didn't write complete jurisdiction in the amendment, right? If there are two, this argument is like, okay, if the word jurisdiction means more than one thing, then wouldn't you want to clarify, particularly for the purposes of the amendment, which one you meant, right? So that it wouldn't be ambiguous, right? So if there are two different kinds of jurisdiction, one of them is called complete jurisdiction, then why didn't they just put complete jurisdiction in the text? Were they trying to make it hard for us? That's interesting. Congress, the intentional consideration is present from the very beginning. The Civil Rights Act underwent several major revisions concerning its definition of citizenship. Senator Lyman Trumbull, the chairman of the Committee of the Judiciary and primary drafter of the Act's citizenship language, recalled for his fellow senators the development of what became the Act's final working. And he said, quote, Senator John Henderson from Missouri and myself desire to arrive at the same point precisely, and that's to make citizens of everyone born in the United States who owe allegiance to the United States. We cannot make a citizen of the child of a foreign minister who's temporarily residing here. That would be a diplomat. There is difficulty in framing the amendment concerning the Act's citizenship clause so as to make citizens of all persons born in the United States who owe allegiance to it. $10 from Marvin CZ. What indication is there that jurisdiction requirement is different from the common law exception to ambassadors in hostile occupation, plus the native tribes who are subject to their tribes? I don't know. That's why we're reading this law review, to try to understand what evidence there is for the proposition. I don't know yet. We'll keep reading. Thank you for your super chat. Okay. I thought it might be perhaps the best form which to put the Act's citizenship clause at one time, that all persons born in the United States and owing allegiance thereto are hereby declared to be citizens. But upon investigation, it was found this sort of allegiance was due to the contrary from persons temporarily resident in it, whom we'd have no right to make citizens, and that form would not answer. It was then suggested that we should make citizens of all persons born in the United States not subject to any foreign power or tribal authority. The objection to that was that there were Indians not subject to tribal authority who were yet wild and untamed in their habits, who had by some means or others become separated from their tribes and were not under the laws of any civilized community, and whom the authorities of the United States took no jurisdiction. It was then proposed to adopt the amendment as it now stands, that all persons born in the United States not subject to any foreign power, including Indians not taxed, shall be citizens. What does the phrase excluding Indians not taxed mean? It's a constitutional term used by the men who made it the Constitution itself to designate what? To designate a class of persons who are not part of the population. They are not regarded as part of our people. The terms Indians not taxed meant Indians not counted in the enumeration of the people of the United States. That's interesting, that idea that Indians not taxed were not counted as part of the enumeration of the United States. Because if that's true, then that suggests that we should not count illegal aliens as part of our census either, which I know that's a lot of interesting ideas too. Senator Trumbull's summary of the Civil Rights Act citizenship language accurately depicts the changes as directly reflecting an intent to exclude from U.S. citizenship not just the children of foreign ministers, but also other persons temporarily resident in the United States from whom a sort of allegiance was due to the country. as well as a particular subset of Indians who had, similarly to temporarily residing foreigners, had never been considered as part of the American people. This distinction between a sort of allegiance due to the United States by temporary residents and full allegiance owned by permanent residents did not diminish during the effort to constitutionalize the provisions of the Civil Rights Act. Early in discussions over the scope of the 14th Amendment Citizenship Clause, Senator Edgar Cohen of Pennsylvania reflected on the differing jurisdictional positions between temporary sojourners who will be afforded basic protections under the proposed Equal Protection Clause and the jurisdictional positions of citizens who no one can doubt are subject to the fullest degree of national jurisdiction. $5 from Paul F. says, they should have just said it was about slaves and their children. Then this wouldn't be an issue. But no, they had to go and use ambiguous language. Well, I will chide you that you seem to be implicitly assuming that if there had been other language, it wouldn't have been ambiguous, which is really hard. It's really, really hard to write language that is completely unambiguous. Give it a try sometime. It's really difficult. So I'm not sure it would have been unambiguous so much as it would have just raised different problems. But I appreciate your super chat in any event. Thank you. Yeah. Do you know how hard it is to write unambiguous legal language? Holy shit. What do you think all us lawyers are getting paid for? To figure out how it's ambiguous, right? Senator Cohen vehemently disagreed with the idea that individuals of Chinese or Roma descent should have the full extent of protection for civil rights, or their children should be treated as citizens. I never quite understood the hatred towards the Roma. I mean, it's like, dude, man. It's telling, however, this objection is based entirely upon the race of the parent and not upon a distinction between levels of allegiance owed to the United States. I guess it's nice that we have something in common with the Europeans, in both that the Americans and the Europeans both discriminate against the Roma. This gets weird considering McGritt, RIP Oklahomans. Fair. Thank you, Cody. Yeah, it's nice that we have something in common with the Europeans. We all hate the Roma. Yeah. It's telling, however, that the objection is based entirely upon the race of the parent and not upon distinction levels of allegiance of the United States. That's another thing, too, that sort of bothers me. It's like when people say, like, oh, the America's uniquely racist. It's like, really? America's uniquely racist? Seriously? Have you seen, like, the rest of the world? Yeah, I don't know about that one, man. I don't know. I think I don't know if America's the least racist country, but I think in the grand scheme we're doing okay. We should be doing better, but I think we're doing okay. This individual wrote the following. The senator wrote the following, I should say. Is the child of a Chinese immigrant in California a citizen? Well, yes, we would answer that question unambiguously later with that Supreme Court case we've been talking about. But apparently this proposition was too much for this senator. So I guess it shows you how times would change. You know, who would think the children of a Chinese immigrant born in California is a citizen? Is the child of a gypsy born in Pennsylvania a citizen? How many gypsies are there in Pennsylvania? If so, what rights do they have? Have they any more rights than a sojourner in the United States? If a traveler comes here from Ethiopia, from Australia, or from Great Britain, he's entitled to a certain extent to the protection of the laws. You cannot murder him with impunity. Please take note, you're not allowed to murder Australians. It is murder to kill him, the same as to murder another man. You cannot commit assault and battery on him. Please do not beat up the Australians. I apprehend. He has a right to the protection of the law, but he's not a citizen in the ordinary acception of the word. In other words, Senator Crown's argument assumes that the Chinese and Roma immigrants are present in the United States in the same permanent capacity as European immigrants, unquestionably, subject to the complete jurisdiction of the United States, but he believed they should not be citizens entirely because they're of Chinese and Roma descent. Senator John Connons of California immediately and rightfully defended the 14th Amendment, not by making such race-based distinctions, and further rebuked Cohen for over-exaggerating the problem of Chinese immigration. Yeah. This response that citizenship would not be withheld from similarly situated immigrants on the basis of race in no way contradicts the simultaneous view that the amendment, like the Civil Rights Bill it was to constitutionalize, made distinctions on the basis of complete and incomplete allegiance owed to the United States. Cohen's concerns were generally ignored as bombastic, and debate progressed to the more pressing topic of excluding tribal Indians. But far from being pushed aside or corrected, his distinction between degrees of jurisdiction, $20 for Marvin CZ, or 2,200 Czech krona, I believe. No, CZ is Swiss krona. Regarding Roma, England had laws calling for them to be expelled from the king's realm as far as 1530. The hatred goes deep. Interestingly, none of the common law precedent from that time or later excludes them from birthright citizenship. The hatred of the Roma goes deep, man. They're just a little bit different than you and I, man. They're just a little bit different from you or I. The Roma are okay with me, man. Yeah. Senator Jacob Howard, who originally proposed the addition of jurisdictional element, defending the adequacy of the language for the purpose of constitutionalizing the language, soon clarified and endorsed Cohen's intertwining view of complete jurisdiction with the concept of citizenship. CZ is Czech. What's Switzerland? I forgot. CH. CH is Switzerland. Right. Well, that's what happens when you try to be real clever and you forget which is which. Lame. Thank you for the check, Krona. I concur entirely with the honorable senator from Illinois in holding that the word jurisdiction herein employed ought to be construed so as to imply a full and complete jurisdiction on the part of the United States, coextensive in all respects with the constitutional power of the United States, whether exercised by Congress, by the executive, or by the judicial department. That is to say, the same jurisdiction in every extent and quantity as applies to every citizen of the United States now. The accepting of different levels of allegiance and jurisdiction would continue to be reflected in debate surrounding Congress's major concern with the citizenship clause. Hey, man, $8 US or whatever, I will happily accept donations, donations of $1, right? That's one of the reasons we make the membership so cheap. It's like, it's literally only 99 cents a month US to join. It's like, I'm more than happy, if 1,000 of you give $1, that's, still pretty good for me. So, if $8 is perfectly fine. So we appreciate the 200 krona. I will happily take the $8.40, and I appreciate your continued support. The acceptance of differing level of allegiance and jurisdiction would continue to be reflected in debate surrounding Congress's major concern with the citizenship clause, where the language subject to the jurisdiction thereof adequately and clearly excluded from citizenship Native Americans living on tribal lands and maintaining tribal ties. All senators with record statements on the matter agreed that the intent of the amendment was to exclude such Indians. But a few senators raised serious concerns that Senator Howe's language was so broad as to incidentally include them anyway. For example, Senator James Doolittle noted that most Indians living on reservations were fed and for all practical purposes controlled by the United States Army at the cost of over $1 million a year to the U.S. government, making them subject to the jurisdiction of the United States and therefore citizens of the language that they stood. Back when $1 million was real money. Back when the U.S. government is spending $1 million a year, man. It's going to break us. He and others proposed incorporating into the language amendment language from the Civil Rights Act explicitly excluding from citizenship Indians not taxed. As this, Senator William Fessenden, chairman of the Joint Committee for Reconstruction, suggested that Senator Trumbull, as chairman of the Committee on Judiciary, who has investigated the Civil Rights Bill so thoroughly, explain his and his committee view as whether tribal Indians were subject to the jurisdiction of the United States. Trumbull dismissed Doolittle's concern, stating the language meant subject to the complete jurisdiction thereof, and it cannot be said of any Indians who owe allegiance, partial allegiance if you please, to some other government, they are subject to the jurisdiction of the United States. As the Senate concluded debate on the citizenship clause, Senator George Henry Williams, also a member of the Joint Committee on Reconstruction, similarly adopted and explained the view that the amendment distinguished between complete and incomplete jurisdiction, and therefore already exclude Indians with tribal ties. In doing so, Senator Williams directly contradicts the modern assertion the citizenship clause jurisdictional element only requires the most basic level of subjugation to sovereign authority. In one sense, all persons born within the geographical limits of the United States are subject to the jurisdiction of the United States, but they are not subject to the jurisdiction of the United States in every sense. Take the child of an ambassador. In one sense, the child born in the United States is subject to the jurisdiction of the United States because if that child commits the crime of murder or commits any other crime against the laws of the country, to a certain extent, he's the subject of the jurisdiction of the United States, but not in every respect. And so too those with Indians. All persons living within the jurisdiction district may be, in one sense, be subject of the jurisdiction of the court in that district, but they are not in every sense subject to the jurisdiction of the court until they're brought by proper process within the power of the court. I understand the words here, subject to the jurisdiction of the United States, to mean fully and completely subject to the jurisdiction of the United States. Once again, personally, I would have been a lot happier if they had simply said that, right? I mean, it's like, oh, we all understand this to be the case. It's like, okay, could you just say that like explicitly? And that might be that, then we might, if it said like complete jurisdiction of the United States, then we might be saying, oh, what does that mean? What does it mean to be under the complete jurisdiction of the United States as opposed to the incomplete jurisdiction of the United States, right? If they had said complete jurisdiction, it contemplates the possibility that there must be such a thing as incomplete jurisdiction. Like that must be a thing. Otherwise, the word is meaningless. So I think I'm going to chide Congress from 170 years ago. Bad Congress. Bad Congress. You probably should have said complete. That would have been more helpful. Shame on you. They just got cold. In short, the theme throughout the debates was not whether there existed a distinction between complete and partial jurisdiction, but rather whether the distinction was clear and specific enough to exclude from birthright citizenship those Native Americans, though born in the geographic boundaries of the United States, were not completely subject to jurisdiction by virtue of their relation to another sovereign. The Indian tribes are just weird legally, man. They are just weird legally. It's like, the whole thing is just weird. It's a mess. It was manifestly clear to the members of Congress that one could be subject to the jurisdiction of the United States in the most basic sense, without being subject to the complete jurisdiction of the United States for purposes of birthright citizenship. While the focus was certainly on the application of the distinction to tribal Indians, it was not limited to them either. Okay. But what does it mean precisely to be subject to the complete jurisdiction of the United States and not merely subject to its sovereign authority? The answer to this question is also found in congressional debates on the amendment and further implied by the context in which the amendment was passed. The purpose of the amendment was to constitutionalize the provisions of the Civil Rights Act and is therefore instructed to understand what Congress understood about the Act's definition of not subject to any foreign power, which once again, they could have put in the constitutional amendment. That would have been nice. And the relationship to the later amendment's language of subject to jurisdiction. The logical conclusion is that Congress understood the phrases as two sides of the same coin, effectively meaning the same thing. That's a problem. You can't really do that because that sort of goes against one of the principles we were talking about earlier. Like different words mean different things and the same word mean the same thing, and we don't like redundancy. So that's a bit of a problem. It's a bit of a problem to say Congress wrote this language and they wrote this other language, and these two languages are exactly the same. It's like, no. If they were exactly the same, they would have like just used the same words because that would have been way more efficient. It's like they must have meant something different. Now, it's true that they might significantly overlap, but to say that they're one and the same would be to invoke a redundancy, which was one of the things we're trying to avoid in the first place. So I don't really like this. I don't like this argument. Are persons born in the U.S. territory citizens, with the exception of American Samoa? Yes. Although I believe that that's by statute rather than the Constitution. In fact, I know it is. So, well, yeah. Except for that one American territory where no one lives that's been incorporated into the United States. And if I could remember the name of that off the top of my head, I'd look really smart. Okay, what's it called? Shit. Yes, with the exception of the one territory that's been incorporated in the United States, yes, by statute. No one lives there. So while you're naming places, it's a place that no one lives. There's a research team there, and that's it. Man. Hold on. Palmyra Atoll. Palmyra Atoll. Okay. The U.S. territory of Palmyra Atoll. Yes. Birthright citizenship. Otherwise, it's by statute. I was definitely going to remember that one off the top of my head. So if you're born in Palmyra Atoll, then yes, birthright citizenship by the Constitution. Otherwise, it's by statute. I'm glad I could clarify that one. Holy shit. Yeah. That's an obscure piece of history. At least I remember that it existed. I got that going for me. So that's something. The purpose of the amendment was to constitutionalize the provisions of the Civil Rights Act and was therefore instructive to understand what the same Congress understood about the Act's definition of not subject to any foreign power. The logical joke conclude. Okay, we read that part. Recall again that Senator Trumbull's explanation for how and why the language in the Civil Rights Act developed. Its drafters specifically intended to withhold birthright citizenship from those who did not owe a complete permanent allegiance to the United States and were not part of the American people. $5 from Senshi. How many gypsies are there in Pennsylvania? Me. Hello. I'm a child of one in Pennsylvania. Well, welcome to the United States, gypsy friend. I hope they are treating you well, gypsy friend in Pennsylvania. Thank you for the $5 super chats. See, not all gypsies are so bad. Some of them super chat you. Some of them give you money. Yeah, Lord. Wow. Okay. They understood this category of persons to include the Native Americans maintaining tribal allegiances, as well as other individuals whose allegiance to the United States were transient or otherwise limited. $10 from Striker A. The distinction is interesting because Teddy Roosevelt made a speech saying, you can't be a hyphenated American. It's all or nothing, leaning into jurisdiction idea brought up here. Teddy Roosevelt is badass, man. Teddy Roosevelt is kick-ass. It's clear that they understood the newly freed slaves as fundamentally distinct in this respect from both tribal Indians and transient aliens. As Representative John Broomhall explained in his introduction to the final version of the Civil Rights Act to the House of Representatives, unlike the temporary sojourner and the Native American, the allegiance of freedmen could not be owned to any government other than the United States. The first provisions of the bill declares that all persons born in the United States are not subject to any foreign power or citizens. What is a citizen but a human being who, by reason of being born within the jurisdiction of the government, owes allegiance to that government? The objection to this part of the bill is that it calls Negroes a citizen. And why should it not? Civilized man must be of necessity be a citizen somewhere. He must owe allegiance to some government. There is some spot upon the earth's surface upon which it is possible for him to commit treason. Now, the Negro in America is civilized, and by of necessity must owe allegiance somewhere. And until the opponents of this measure can point to the foreign power to which he is subject, the African potentate to whom after 5 generations of absence he still owes allegiance, I will assume him to be, what the bill calls him to be, a citizen of the United States in which he was born. Wow, that's some language, man. That's some language. By the way, thank you for the 457 of you who are here and spending some time with me. If you haven't hit the like button, now would be an excellent time to do so. And did you know for 99 cents, you can become a member of the channel? It's true. Just hit that beautiful, beautiful join button. And for 99 cents a month, you become a member of the channel. You get behind the scenes content, such as you get to watch me do editing sometimes. That's exciting. And you get access to like gaming streams. That's exciting. And you get access to some emojis and you get your name in green. Plus, you know, that feeling of just being a little bit better than everyone who didn't donate 99 cents a month. So, you know, do those things. Help me pay my taxes. Become an uncivilian today. Senator Trumbull's summary of the Civil Rights Act for President Johnson offers another insight into the meaning of complete jurisdiction and allegiance. The importance of domicile is a determining factor. And this is something we were spending some time with discussing in the concept of the Supreme Court case. We were previously reading this concept of domicile. As he explained to the president, the Civil Rights Act declares all persons born of parents domiciled in the United States to be citizens of the United States. His paraphrase is consistent with the debates leading up to the bill's package and the purpose of excluding from citizenship the U.S.-born children of temporary sojourners who are presumed to still be meaningfully subject to the government of the country to which their parents intend to return. There is, too, the well-documented understanding of citizenship by Representative John Brigham, who is often called the father of the 14th Amendment because of his great involvement in its drafting. Consider Brigham's discussion of the constitutional citizenship during the drafting of Oregon's 1857 Constitution. Who are the citizens of the United States? Sir, they are those, and those only, who owe allegiance to the government of the United States, not the base perpetual allegiance imposed upon the Saxon by the conqueror, which required him to meditate in solitude and darkness at the sound of curfew, but the allegiance which requires the citizen not only to obey, but support and defend, if need be with his life, the Constitution of his country. All free persons born and domiciled within the jurisdiction of the United States are citizens of the United States from birth. His understanding and allegiance of domicile as part of the parcel with citizenship was documented again in 1862, during which debates over emancipation within the District of Columbia. Who are natural-born citizens but those born within the Republic? Those born within the Republic, whether black or white, are citizens by birth, natural-born citizens. All other persons born within the Republic, of parents owing allegiance to no other sovereign, are natural-born citizens. There's some pretty interesting language in here on this proposition. There's some pretty interesting language in here on this proposition. So this might be a more interesting legal fight than I initially gave it credit for. And it might be a more interesting legal fight than I initially gave it credit for. Interesting. Oh, Lord. Would Wong Kim Ark be granted citizenship? He was granted citizenship. And Wong Kim Ark was granted citizenship. That's, well, you mean, yeah, I mean, yeah, I don't, but because his parents were domiciled here. Yeah. I am concerned about the potential retroactive effects of this, though, because we're talking about constitutional language. So I'm concerned, notwithstanding the EO's language, that this could have retroactive effects. I don't know if the Supreme Court would do that, but it's a concern. And if it does have retroactive effects, just how deep do those go? Which is probably one of the reasons, if anything, the Supreme Court won't do it, because it's like, do you really want to go all the way back down to like the 14th Amendment? Do you want to go back and try to figure out citizenship for 150 years? That sounds like a lot of work. So, yeah, but I'm still concerned about its potential retroactive effects. The 14th Amendment was intended, consistent with the Civil Rights Act, it's constitutionalized, to bestow citizenship upon permanent or long-term residents who do not owe allegiance to another sovereign and are therefore counted as part of the American people. In defending the amendment against the effort to include the words "excluding Indians not taxed," if this case goes to the Supreme Court, I'm going to this oral argument. I haven't been to the Supreme Court oral argument since I lived in DC, but I think for this one, I might make the trip. So that I can be in the room where it happened. One of the perks of being a member of the Supreme Court bar is I get to stand in the Supreme Court bar line, which is shorter. I still have to show up early because the room is really small, but I get to stand in the Supreme Court attorney line. I'm special. It's exciting. Yeah, so I probably have to show up early, but not quite as early as, if I were in the public line. Also, I get better seats. The Supreme Court bar members get better seats. We get to sit further up front than the plebs. The plebs have to sit in the back half of the courtroom. Supreme Court bar gets to sit in the front half of the courtroom. So. I also get to sponsor other attorneys to become members of the bar. I know. If someone wants to become a member of the bar, perhaps we can choose this as your swearing date, and we can do it in person, because then we'll get front row seats. I did not propose to say anything on the meaning of the amendment except this question of citizenship has been fully discussed in this body as to not need further elucidation, in my opinion. The amendment to which I've offered is simply declaratory of what I regard as the law of the land already, that every person born within the limits of the United States and subject to their jurisdiction is, by virtue of the natural law and natural law, a citizen of the United States. This will not, of course, include persons born in the United States who are foreigners, aliens who belong to families of ambassadors, misspelled, or foreign ministers accredited to the government of the United States, but will include every other class of persons. Given that the purpose of the amendment was to put the protections and rights afforded by the Civil Rights Act beyond the easy reach of the subsequent Congress, the law of the land already to which Senator Howard refers is none other than the Civil Rights Act itself. This is incredibly damaging to arguments by universal birthright citizenship advocates. The Senator Howard statement was grammatically ambiguous, and he meant merely that foreigners and allies excluded those who belonged to foreigners, families of members, and foreign ministers. The Civil Rights Act, as the law of the land, excluded not only those children of ambassadors and foreign ministers, but also those foreigners who only owed the sort of allegiance as a result of their temporary residence in the country. In this light, the only natural reading, and the reading consistent with the rest of the legislative history, is that Senator Howard effectively said this will not, of course, include persons in the United States who are foreigners, allies, aliens, or those belonging to families of ambassadors or foreign ministers. So, I mean, there's definitely some language for this proposition, man. There's some language for this proposition. I mean, if I were going to argue this in front of the Supreme Court, I would have to tear this the absolute fuck apart. You know, like I'd have to tear this the absolute fuck apart if I were going to argue this in front of the Supreme Court. I want to see every statement made by every legislator in the Congress or any of the states during the ratification debates on this. I want to see what every word everyone had to say on this issue was. I have to absolutely tear it apart, you know, to try to figure out exactly what they were talking about. Plus, any contemporaneous legal writings beyond that would also be helpful. A lot of work. It was not just Senator Howard who tied the jurisdictional elements of the 14th Amendment Citizenship Clause back to the Civil Rights Act, the citizen's not subject to any foreign power. And of like all the ones to argue in front of the Supreme Court, I think this one might be beyond my pay grade. I know I like to have a pretty strong opinion of myself, and I think to some degree well earned. I'm pretty well informed on the Supreme Court as recognized by my peers. And although I'd love to argue in front of the Supreme Court, I don't know, man. I think this one is beyond my pay grade. This is, yeah. This is, yeah. All that the amendment provides is that all persons born in the United States and not subject to some foreign power for that, no doubt, is the meaning of the committee which brought the matter before us, shall be considered as citizens of the United States. If I were doing this, I need like half a dozen paralegals, and we need a room, and no one's allowed to leave for like 6 months. And look, Christ. And they're citizens of the United States entitled elsewhere to be characters of citizens of the United States. There'd be some definition of what citizenship is, which created the character of citizens between himself and the United States. And the amendment says the citizenship may depend upon birth. And I have no other way to give rise to citizenship than the fact of birth within the territory of the United States, born of parents who at the same time were subject to the authority of the United States. You'll supply snacks? Excellent. We're going to need lots of snacks. We're going to need lots and lots of snacks. Many, many snacks. In this way, Senator Johnson, like Senator Howard, connected the Civil Rights Act to the 14th Amendment and recognized they accomplished the same exact goal of excluding from citizenship. It's like 8 pages in the Senate debate. Well, that's a start. Those individuals who were subject to the foreign power of the Civil Rights Act were simultaneously not subject to the full and complete jurisdiction. I have a hard time believing the 14th Amendment only had 8 pages of debate in Congress. That might have been one of the debates. I have a hard time believing that's all the debates that Congress did. I mean, it's like, I find it a bit difficult to believe that Congress was like, you know what we want to do? We want to create an amendment to the Constitution, and we only need 8 pages of debate in order to do that. I don't know, man. I think there might be some more pages you're not counting. Just the debate on subject to the jurisdiction? Oh, man, forget that. I want to read it all. No, I want to read every single word of no. I need to read every single word that even breathe about the 14th Amendment. I need to read it all. Yeah, I don't trust how they decided to break it up later in the printed record. I need to read it all Pokemon style. Ann Bell Feinstein for $5 said, not a paralegal, but I have fascination with reading and dissecting stuff. I spent a month on a fact for a fiction manuscript. Fair enough, man. Fair enough. Guru for Hire here Says, I actually think it's pretty simple. Well, wrap it up, boys. Wrap it up, boys. Cougar for fire. Things are simple. Pack it in, guys. We don't need to keep talking about it. Oh, man. Oh, Lord. Oh, Dave, no, I need to read it all. I need to read everything. I mean, I want the congressional debates. I want the debates from the state legislators. I want every public statement that ever breathed about this. Any statements by the president, anyone else who was a public official. I need to read basically every word that was spoken about the 14th Amendment. I need to read everything that was said out loud. It's like, in order to try to make a legal argument about this, it's like, yeah, you need to read it all to try to figure out what you're doing, man. It's going to take a hot minute, man. No, that's okay. I don't need the tiffs. I'm good. Thank you. This is fine for the moment. Yeah, was it ratified? Yes, it was ratified. No, we are not having this discussion. In this way, Senator Jensen, like Senator Howard, connected the Civil Rights Act with the 14th Amendment and recognized they were accomplished with the same goal of excluding from citizenship those individuals who are permanently to the sovereign power of the United States. Senator Trumbull employed similar reasoning to confront the argument that additional language is necessary to exclude Indians not taxed. After explaining the amendment bestowed citizenship only on those subject to the complete jurisdiction of the United States, he clarified that being subject to the complete jurisdiction of the United States meant not owing allegiance to anyone else. Because tribal Indians owned partial allegiance to their tribe, which are considered to be quasi-foreign, they were not subject to the complete jurisdiction of the United States and were therefore not citizens of under the 14th Amendment. The connection between the Civil Rights Act and the 14th Amendment also helps to make sense of Senator Connie's rebuke of Senator Cohen for a series of questions about whether the U.S. children of Chinese immigrants and gypsies could be considered citizens. I like these twin categories. Like, who do we not trust? We don't trust Chinese people. And we don't trust gypsies. I don't know, man. It's just like, these are the twin evils we need to watch out for. The Chinese and the gypsies. I don't know, man. It's just like, okay. Okay. What if they're a Chinese gypsy? How about that? Did anyone ever think about that? What if they're a Chinese gypsy? What do we do then? The proposition before us, I will say, Mr. President, relates simply in that respect to the children begotten of Chinese parents in California, and the proposal declared that they shall be citizens. We've declared that by law. Now it's proposed to incorporate that same provision in the fundamental instrument of the nation. I'm in favor of doing it. Senator Connie's plainly invoked the Civil Rights Act as that which has been declared by law, and we're incorporating into the Constitution itself. The constitutional provisions stated those born in the United States and subject to their jurisdiction were citizens was already the law, and through the statutory provisions, providing those born in the United States and not subject to any foreign power were citizens. That's actually like a really interesting, that's a really interesting legal question, incidentally, too. Because the Civil Rights Act predated the 14th Amendment, the Civil Rights Act is arguably not valid, except because of the 14th Amendment. And the 14th Amendment can certainly make it valid retroactively. But that sort of implies that you can use the statute and the statutory history to interpret the Constitution, which normally you wouldn't do that, right? Because it's the wrong way around. But in this case, the statute precedes the Constitution, and it's like the same language and stuff. So actually, in addition to every word spoken about the 14th Amendment, I'm also going to need every word spoken about the 1866 Civil Rights Act, because I might be able to use that legislative history to interpret the 14th Amendment. There might be something in there. The debate on the 14th says the text of the 14th means the same as the CRA. See, even more reason I need a copy of that, right? If like that's even more of a reason I need a copy of that too. So I'll take a copy of that too. Just please add it to my library of things. The difference between gypsies and Chinese might be that gypsies were not considered legal permanent residents or domiciled. The gypsies are getting no love, man. The gypsies are just not getting any love, man. They are just not getting any love. Paul F., $5 says, isn't the best counter argument to legislative intent found in debates the final wording of the law itself? Well, that's definitely a thing. But, you as a lawyer, obviously, you want everything that can possibly make your argument for you, right? You want it all. And then you have to figure out so first is like identify literally every possible thing that can make my argument. Like identify all the things that I could possibly use to make the argument. Incidentally, either way, like the lawyers for the other side should do this too. Like literally identify everything that could possibly be used to make my argument. And then try to figure out which is the best of those things. Because I can't use everything. I'm gonna have to narrow it down, but until I have it all, I don't know. So it's like give me everything and then I'll figure out which is the best thing, right? If you're a gypsy, please know that you're loved here on Uncivil Law. We love you. In the other words, the U.S.-born children of Chinese immigrants and gypsies were subject to the complete jurisdiction of the United States because they are already considered as not subject to any foreign power. The senator's understanding of the context in which these children were born is fundamental importance and informs his reasoning for the conclusion. He characterized the Chinese immigrants as generally having no intent on abandoning their allegiance to China or permanently residing in the United States. Those immigrants who did bring their wives and children then were not merely temporary sojourners. This person really likes the word sojourn. I mean, I like the word sojourn too, but this person really has a hard-on for the word sojourn. How many times can they use the word sojourn? Damn. We're not temporary sojourners, but rather presumably intended to stay in their country on a long-term or permanent basis and subject themselves and children to complete U.S. jurisdiction. The children of permanent resident aliens already fit within the category of citizens envisioned by the Civil Rights Act, and no one would have doubted this reality had they instead been born of European descent. Presumably excluding Roma, which I suppose is not European for the purpose of this discussion. There's a good one. Are Roma European? Because it seems like no. In fact, I'm not sure the Europeans consider Roma to be European. Are they? Are Roma European? That is a question I didn't know I had today, but that's what we're doing. There's one more dilemma regarding the language of the Citizenship Clause, which must be addressed. If the 14th Amendment was meant to reiterate the protections of the Civil Rights Act, why did Congress not simply reiterate the Act's definition of citizenship? Or some commentators have posited, if Congress meant subject to the jurisdiction means something more akin to owing permanent undivided allegiance, why did they not revise the language accordingly? That's the question I've been asking. I don't need a copy of the CRA in 1866 right now, Silicon. I don't actually need it. Okay? I have not, as of yet, been hired as an attorney to argue this. So I don't actually need it right now. I was just saying what I would want if I were an attorney doing it, but I don't actually need it right now. But thank you anyway. I don't need a copy of the 1866 Civil Rights Act. I'm good, thank you. I'm good for the moment. If you'd like to hire me to do this, I'm going to need a big pile of money because it's going to take a lot of time. This would take a lot of time. I'm going to need a big pile of money. Yeah. Southeastern Europe, not so much. Yeah, I mean, this is hundreds of thousands of dollars. This is probably seven figures by the time we're done. As much legal research as we're going to need. Oh, Lord. Does birthright citizenship automatically convey citizenship? By necessity, yes. Or legal residency, also yes, because if you're a citizen, you're necessarily a legal resident. Those would be hard to not be true at the same time. How many channel memberships do I need? More. A similar argument about the breadth of Indians not taxed was raised alongside concerns. This could be reasonably interpreted as excluding from citizenship poor Indians who had cut ties but were not subject to any sort of property or wealth tax, while incidentally including tribal Indians for many, for whatever reason, subject to state or federal tax. I mean, we need to get like an office somewhere. I mean, I don't even have space for the amount of paper I'd have to do. I mean, literally the paper. Because, I mean, I can't print out that much stuff and just have it spread around my apartment. I'm going to need an office somewhere. I'm going to need an office, and I'm going to need like a conference room, and I'm going to need, I don't even know, the mother of all filing cabinets or something. It's, MG Law can work for me. Well, I'll hire MG Law. He can work for me. Start tearing it apart. Man, lots of highlighters. Yes, a lot of highlighters. Yeah. Gonna need a lot of pen and a lot of highlighters for 30 minutes of argument at the Supreme Court. Yeah, it's gonna take us a couple of years and $1 million for 30 minutes. Yeah, but what's said during those 30 minutes, that's the thing, right? The confusion over whether the language of the previous acts was the clearest way of excluding tribal Indians was significant enough, the measure to reintroduce it into the amendment failed. In the end, Senator Howard's proposed language of subject to jurisdiction thereof survived under a general consensus to provide an adequate, clear bar for citizenship on the basis of undivided, complete allegiance to the United States government, a bar they understood as excluding both those who owed allegiance to foreign power and Indians who owed allegiance to tribal governments. Why not then simply use the term allegiance instead of jurisdiction? Good question. Recall once again that Senator Trumbull's statements on the history of language in the Civil Rights Act. The use of the term allegiance was considered and expressly rejected because it could have been construed under the English common law as including those who owe a sort of allegiance, such as temporary sojourners or Indians born within the sovereign dominion of the United States. But you have the same problem for jurisdiction, man. You have the same problem for jurisdiction. Under the English common law, allegiance was a term of art, and its meaning, as will be discussed in depth below, was incompatible with the consent-based allegiance understood by the founding generation and envisioned by the Reconstruction Congress as a basis of citizenship. An adequate Republican substitute for feudal concept of allegiance was that of jurisdiction, particularly in the sense intended by Congress. Complete subjugation to jurisdiction that defines those who are part of the American people as those who were temporary residents or otherwise particularly subject to the jurisdiction of another sovereign in a meaningful way. Finally, and perhaps most importantly, the Civil Rights Act continued to operate as valid federal law for the next 70 years, codified under Section 1992 of the revised statutes of the United States, a precursor to the U.S. Code. Exciting. The Section 1992 was repealed by the Nationality Act of 1940, which replaced the original statutory language with a definition nearly mirroring that of the citizenship clause. Okay. John Jay, who originated subject to jurisdiction, did he really? That's fun. It was not redacted, stricken, or repealed in various editions of codified federal law, meaning the United States effectively had two definitions of citizenship, one statutory and one constitutional, coexisting in the same legal framework. As evidence below, both courts and scholars presume these two definitions expressed, if not identical meanings, then certainly compatible or complementary ones. This significantly strengthens the argument the Civil Rights Act and the 14th Amendment were understood primarily as accomplishing the same purpose, and those who understood subject to jurisdiction in the United States were understood as not subject to any pardon. And it led to George Washington? Cool. If President Trump is successful with revoking birthing rights in the 14th Amendment, how would it affect us? Well, it would only impact people born of illegal aliens and born of legal but temporary aliens. So it wouldn't impact me, and it wouldn't impact, I imagine, the vast, vast majority of people in chat. So the only people it would impact are people who are born to parents, plural, neither of whom was a naturalized or natural born citizen. So if you're a child of at least a naturalized or natural born citizen, this will not impact you. If you're not one of those things, it may impact you. Now, the EO itself says it's only forward-looking. The EO itself says it only applies to people born 30 days after the EO. But I'm by no means confident that that provision will necessarily be a limiting effect in the end. It may be, but I don't think by any means it's guaranteed. So it's possible, although somewhat unlikely, but it's at least possible in my humble opinion, that some people that are considered citizens today will not be considered citizens in the future. And although, of course, if that happened, like unwinding all that would just be such a pain in the ass. Like if you had to unwind, could you imagine? Could you imagine just practically? Could you imagine trying to unwind people you've been treating as citizen and now unwind it so retroactively they're not citizens? Like, I think the practical factor is the most likely thing to prevent that from happening, because it just feels like an absolute total nightmare. Couldn't the fact they came here illegally be synonymous with the fact they not revoked their citizenship? Yeah, but it's not necessarily, yeah, but we're talking about the children of those people, not the people themselves, the children of those people. Just because something is hard doesn't mean you don't do it. Sometimes it does. Sometimes it does, because the remedy is ultimately up to the court, right? The remedy is ultimately up to the court. So sometimes it's too hard. Yeah, sometimes that means you don't do it. It does absolutely mean that, but it doesn't mean that you don't. It doesn't mean that you don't do it. It's just sometimes you don't. So it's a possibility. 999 from Squirty Belly says, if they're using the argument of not owning allegiance to the other country also to be used to deny citizenship of children a permanent residence because they still retain citizenship of another country. No, I don't think so, because the America doesn't necessarily preclude people from being dual citizens. And lawful permanent residents, green card holders, don't have to give up their citizenship, to the best of my knowledge. So, no, I don't think so. So just because they have citizenship somewhere else doesn't mean they don't have citizenship here. Those are distinct concepts, right? So I don't think so, not necessarily. Yeah. If they didn't remedy Chevron, they won't remedy this? Fair. Yeah, it's like we're definitely not trying to undo 50 years of Chevron law, right? Or, 40 years of Chevron. We're not trying to undo all that shit. So they wouldn't undo all this. That's very, very fair. I appreciate you being here and spending some time with me today. And thank you, by the way, for everyone who was so kind in expressing their thoughts and concerns and prayers for my mom. For those of you who are religious, I will absolutely accept your prayers. My mom is in the hospital and has high blood pressure that has been unable to be treated for several months. And so she's in the hospital, and I am concerned about her. I appreciate that you're here and spending some time with me so I don't have to think about it too hard. Contemporary legal scholarships have also looked in the order to discern a legal text's original public meaning, especially when there's wide consensus among them as to the text's meaning. Can illegals who've committed no other crime be prevented from leaving the U.S.? No. A review of scholarship in the decades following the ratification of the 14th Amendment provides ample support for the argument the Citizenship Clause was originally understood not just by Congress, but also the preeminent legal minds of the day as referencing a complete jurisdiction that would exclude from birthright citizenship a far broader class of aliens than just foreign ambassadors and ministers of common law. Renowned constitutional expositor Thomas Cooley, I haven't heard that name in a while, in his 1880 treatise, The General Principles of Constitutional Law of the United States. Cooley is one of the worst law schools in the country, so that's one of the reasons his name is kind of funny. It's like, Cooley sucks. The school sucks. Describes the importance of the 14th Amendment in terms of its connection with an earnest and violent controversy which for more than 10 years previous to its adoption has agitated the country respecting the status of colored persons. He then explained how the American Amendment functioned to correct the decision in Dred Scott and wrote regarding the acquisition of citizenship. The 14th Amendment indicates the two methods, The 14th Amendment indicates the two methods in which one may become a citizen, first by birth in the United States and second by naturalization therein. But a citizen by birth must not only be born within the United States, but he also must be subject to the jurisdiction thereof. And this has meant that a full and complete jurisdiction to which citizens are generally subject, and not any qualified or partial jurisdiction, such as may be consistent with the allegiance to some other government. The Aboriginal inhabitants, that's weird. You know, you don't normally hear of native-born Americans called Aboriginals. So that's interesting language. Just, you know, it's just odd to the American ear. But okay. The Aboriginal inhabitants of this country may be set in this anomalous conflict, so long as they preserve the tribal relationship and recognize their headship of their chiefs, even when they reside within the state or an organized territory, and owe an unqualified allegiance to the government of the United States. It would obviously be inconsistent with the semi-independent character of such a tribe, and with the obedience yielded by them to their tribal head, or they should be vested with the complete rights, on the other hand, charged with full responsibilities of citizens. This is from what year? This is from (1880). But when the tribal relations are dissolved, or when any individual withdraws and makes himself a member of their civilized community, adopting the habits of its people and subjecting himself fully to their jurisdiction, the right to protection in persons, property, and privilege becomes as complete as that of any native-born inhabitant. They called the Indians savages and wild in the debates. I saw that, yes. Natives didn't become full citizens until the 1900s. You're correct. By statute, you're absolutely correct. In his 1881 book, Treatise on Citizenship, Alexander Porter Morse, $10 from Shotgun Breakfast. Is it worth revoking birthright citizenship just to see Kamala Harris and Hassan Piker get deported? Well, I don't know enough about Kamala Harris's parents in terms of where their status when Kamala was born. I thought both of her parents were legal and domiciled here. Was that not true? So I don't think it would apply. As to Hassan Piker, yeah, I'm happy to deport that guy. I don't really care. Yeah, neither of them would be denied citizenship by the CEO. Yeah. I wouldn't think so. Persons born in the United States or have, according to laws of foreign country, become subjects or citizens thereof, must be regarded as aliens. Under this principle, that children follow the condition of their parents, children of aliens and the accident of whose birth occurs in American soil, and minors commemorate in the country are invested with the national character of the parent. The section of the 14th Amendment does not confer citizenship upon persons of foreign birth. The word subject to jurisdiction thereof excludes the children of foreign transiently within the United States as ministers, consuls, or subjects of a foreign nation. The amendment does not include Indians and others not born in and subject to the jurisdiction of the United States, but an Indian, if taxed after tribal relations has been abandoned, is a citizen. Francis Worden, in his 1881 edition of the Treatise on Conflict of Law, similarly noted that when a child was citizen under the 14th Amendment depends upon the question whether his child was at birth subject to the jurisdiction of the United States. He further explained in language similar to that seen in ratifications debate that the amendment does not mean subjugation to one mere sovereign authority. In one sense, the child of an alien temporarily in the United States is undoubtedly subject to the jurisdiction of the United States. All foreigners are bound to a local allegiance to the state in which they sojourn. There's that sojourn again, man. Yet the term subject to the jurisdiction as used above must be construed in the sense in which the term is used is international law and accepted in the United States as well as Europe. And by this law, the children of those born abroad of American citizens are regarded as citizens of the United States with the right upon reaching full age to elect one allegiance and repudiate the other, such elections being final. The same conditions apply to children born of foreigners in the United States. Wharton's analysis was distinct from Morse above and Miller below, in that while he understood there to be two different types of jurisdiction, he argued that both applied to make the U.S.-born child of temporary present aliens a dual citizen until he or she reached the age of majority. This election of allegiance at the age of majority is a hybrid of both common law just solely, citizenship by birth on the land alone, and consent-based citizenship theory that did not gain traction or garner much support from either elites or scholars. All right, I need just a second to breathe and not be reading this because my mind is just slightly fried. How y'all doing? Let's talk about something else for a second. What's on your mind? Is it snowing where you are? Are you trapped inside? You're coding? Excellent. What are you coding? Life is good? Glad to hear it. Take a brain and muscle break, do some stretches. I'm telling you what, man. Just a little bit of stretch time. You're visiting your dad, having fun with your doggo? Excellent. Will Hegseth be confirmed? I don't know. The one I'm personally looking forward to is Tulsi Gabbard. I'm looking forward to Tulsi Gabbard and maybe RFK. We're definitely streaming Tulsi Gabbard's confirmation hearing next Thursday. I'm pretty excited about it. It should be pretty epic. You stabbed an inch or so of rusty wire into your forearm? Well, that's no good. You're reviewing and electronically filing stuff in bankruptcy cases. Okay. All right. Does mutual combat laws cover dueling? Depends on your jurisdiction. Please consult your state law. You're playing with your new espresso machine? That sounds nice. Let us return to this. The election at age of majority is a hybrid of both common law jus soli citizenship on land alone and consent-based citizenship theory that did not gain traction or garner much support among either the courts or other scholars. It does, however, serve to repudiate any notion that contemporary legal scholars understood the 14th Amendment to have adopted common law jus soli, which would not accommodate an election to allegiance. Similar reflections on the citizenship clause and complete jurisdiction were espoused in 1891 by then recent Supreme Court Justice Samuel Miller, who observed that the U.S.-born children of aliens temporarily residing in the United States are not born subject to the jurisdiction and are not citizens. This understanding of law was also touted in Columbia Law Times article same that year in an 1895 Law Review article that by then U.S. Chief Justice of Samoa, Henry Idle, and then again by 1897 by former U.S. Representative and then Ambassador Boyd Winchester. The significant agreement among contemporary legal scholars is further underscored by the opinions of various executive branch officials during the same time, including Secretaries of State. For example, in 1885, Secretary Thomas Bayard analyzed the case of a man born in Ohio to German parents who remained domiciled in Germany when he was only 10 years old. Give me 1 second to fix something because it's driving me a little crazy. There we go. That's better. For example, in 1885, Secretary Thomas Bayard analyzed the case of a man born in Ohio to German parents who remained domiciled in Germany and who returned with his parents to Germany when he was only 2 years old. Secretary Bayard instructed the man should not be considered a United States citizen. Richard Gracer was no doubt born in the United States, but he was on his birth subject to a foreign power and was not subject to the jurisdiction of the United States. He was not, therefore, under the Act and Constitution a citizen of the United States by birth, and it is not pretended that he has any other title to any other citizenship. So, this is an example of the Secretary of State, at least, in 1885, determining that a man of German parents who were still domiciled in Germany was not a U.S.-born citizen, even though he was born here. So that's pretty interesting precedent. Earlier that year, then Secretary Frederick, am I really going to have to pronounce this name? Then Secretary Frederick Frelinghuysen had examined the case of Ludwig Halsding, who had been born in the United States to his German father and had returned to his father to Germany while still an infant. Ludwig's father later returned to the United States and became a naturalized citizen, but Ludwig continued to reside in Germany. Ludwig was denied a U.S. passport under these circumstances because, according to the State Department, his claim for citizenship on the basis of his birth alone was insufficient. Again, the State Department is making this determination, which, is not nothing, it's something. The fact of birth in the United States under circumstances implying alien subjugation establishes itself no right of citizenship, and the citizenship of a person so born is to be acquired in some legitimate manner through the operation of statute. A similar assessment of the law can be even seen 5 years later in the 1890 opinion of then Secretary of the Treasury, F.A. Reeve, regarding the citizenship of a child born to a would-be immigrant who had not landed but was awaiting immigration approval. The child was determined not to be a citizen even though he was clearly born on U.S. soil after the mother had been allowed to disembark the ship and receive treatment at a New York hospital. That other secretaries of states may have reached somewhat different conclusion merely underscores the fact that the executive branch was given significant leeway, perhaps too much, in interpreting how the citizenship clause should be applied to circumstances outside of those most common to the claims of natural-born citizens and most clearly associated with the amendment. It's hardly surprising that President Chester Arthur, in his 1884 State of the Union address, called on Congress to clearly define the status of persons born within the United States subject to a foreign power and of minor children of fathers who had declared their intention to become citizens but failed to perfect naturalization. Regardless of the executive branch uncertainty of the subject, however, it's clear that numerous preeminent legal scholars understood the clause as excluding a broad class of individuals not subject to complete jurisdiction. The significant agreement can be best summarized in the general rule outlined in Wharton's international law, the reasoning which excluded international tribal Indians from automatic birthright citizenship arguably would exclude children born in the United States of foreigners here on transient residence. Well, my friends, I think that's probably going to lead us to the end of the stream for today, because then they're just going to discuss, like, things beyond the original date and what little Supreme Court law there is on point. So my thought here is that there is more to this argument than I thought there was. I don't know that I have an opinion yet, because I need to chew on this. I need to chew on this a little. So I don't know that I have an opinion yet. And to the extent that there are law review articles that go the other way, perhaps based on originalism ground, I would like to read those too. Right? So to the extent that there are law reviews or other legal commentary, especially from originalist point of view, that says that disagrees with us, I would like to read those too. So I think it's a little premature to say what I think about the ultimate question, but I think it's a better argument than I initially gave it credit for. It's a better argument than I gave it credit for. Yeah. Am I sure I don't want the Congressional Globe scans? I'm kind of sure. CZK for 100 check Corona. Aside, I like the explanation in the common law hostile occupation exception by James Kent. Those on occupied land, the conqueror gains the rights of the conquered as to dominion and government. Fair enough. The Wong precedent hinged upon him being a permanent resident. I don't know if hinged is correct. It was certainly true, but the degree to which it hinged on that is debatable, at least in my opinion. But it's a very interesting argument. The amendment was to include then existing slaves, not future migrants. Well, maybe. Although the Van Ark case disagrees with you. Thank you very much for the support on coffee, AD. I don't think I'm ready to stop the stream yet, though. I don't want to be alone. I don't want to be alone right now. So I don't know if I want to just try to take a break and pick up part 2 of this. I don't know if I want to play games. I don't know what I want to do, but I don't feel like I want to be alone right now. Both my parents have health issues, which makes sense since they're in their mid-70s. But yeah. I think it's possible that my parents might be mortal. That fact does not please me. Life is too short. Life is too short. It took me a really long time to accept that I wasn't a college student after I graduated. But these days, like I was watching, we were watching the presidential inauguration, right? And I was like, I commented as we were watching it. We were watching like the high school bands, and I'm like, these are children. And I'm like, that sort of like revelation is somewhat disconcerting. You know, that revelation is somewhat disconcerting. When you find out Back to the Future was 40 years ago, yeah, yeah, yeah. Wasn't that 70s show like in when was that 70s show? Was that 90s? It was like only 20 years ago or something, 20 years before. When did that 70s show go on air? What year was it? 98. 98. So that 70s show was 98. All right. So if 1998 is 1970, then 2025 is, well, let's see. It would be 28 years ago, right? So that would be 1998. Wait, can that be right? Wait, that is right. Right? Yeah, that's right. If 1998 is 1970, then 2025 is 1998. $1998. So that would be like me starting a show called the 1998 show. So that would be the equivalent of me putting out a show today that's called the 1998 show. Holy shit, I just feel like I got called old in 18 different languages. That's not fun. Yeah. Yeah, that's I graduated high school in 99. I graduated high school in 99. Man, I feel old as shit. I started college in 99. 2000 party is over. Oops, out of time. We're gonna party like it's 1999. 1999. How do things turn out with Nick Rekieta? Let's see if there's an update on his case yet. No transcript yet. No, well, maybe later. No transcript of his sentencing. No, maybe later. The Matrix anniversary? Matrix was a while ago, yeah. Does anyone? Yeah, the 60s, 70s, and 80s were pretty distinct. Do you think it's true that like things have been kind of the same since 1990? Like, I mean, the 60s, I mean, the 50s, 60s, 70s, and 80s feel like such distinct errors, right? To my mind, like the 50s, 60s, 70s, and 80s seem like such distinct errors. But I don't have like that same distinction from like 90 on. Have there been like distinct errors like that since the 90s? Yeah, since 2000. Yeah, it could be a music thing. It could be a music thing. There probably isn't as much because we no longer really have radio. I mean, we do, but you know what I mean. There's probably not really one music like there was. There's no. Everyone's got their own Spotify now, right? Everyone's got their own Spotify, so there's not like everyone's listening to the radio and listening to the same songs. So the music is less homogenous. The JFK, RFK, MLK actual info. The actual info is not going to be released for a while. It's unclear when it will be actually released. Everything kind of runs together. Yeah, I think everything runs together more. The internet has leaded. The internet has probably produced a more homogenous culture too, in a lot of ways. Well, I think I'm going to sign off, and unless you guys want to like play a game or something, you guys want to just hang out, play like some murder mystery game. Why not? Let's do a couple rounds of murder mystery game so that I don't have to sign off. Murder trivia. Murder trivia it is. It's not trivia about murders. It's just, it doesn't matter. All right. So for those of you who want to play, go to your browser of choice and go to jackbox.tv. Jackbox.tv. It's going to ask you for your name and it's going to ask you for a 4-letter code. If you're nice, I will give you the 4-letter code and then you can play the game with me. You download Fall Guys? We could play Fall Guys too, maybe. Let's play this because it's universal and it's easier. Okay. Neat. All right. Are you going to load or are you not going to load? Are you going to load or are you not going to load? Hold on. Okay, it's not going to load. All right, hold on. I need to do something first so that I don't lose you when I drop. All right. Yeah, you don't have to own the game. That's the nice thing about it. You don't have to own the game. All right, so I need to disable auto stop so I can drop my VPN connection so that I can. Okay. Come on. RXVK. RXVK is your code. RXVK.
This is your wake-up call. Prepare to die. Welcome to Trivia Murder Party. Your free weekend getaway was a trap, luring you into a game of life or death. Only one of you will survive. It's all pretty standard family vacation stuff. Okay, first question. According to the Oxford English Dictionary, what's the least frequently occurring letter in English? Use your device to answer the question. I'm talking to you too, audience. Time's almost up. And the correct answer is... Who got the question right? The rest of you, I want to show you something.
Everyone other than me got it wrong.
Put on the Do Disturb sign. We're at room 101. Ah, the old skewers trick. Pick a space in this box to hide yourself. When this was used in magic shows, there were safeguards inside to prevent injury, but don't worry, I took those out. Choose now, or I'll choose for you. Any good magic trick needs some helpful volunteers. Volunteers get 1 sword. On your device, choose a row or a column to... Sword noise! Oh, I needed that.
Sorry, Jaren. RXVK is the code. RXVK. You can always join the audience.
Surprise! Okay, so don't freak out, but you're a ghost now. Keep playing and you just might steal someone else's life force and win the game. Oh, also, there's an audience in the game. If they survive, you die. If you're not ready now, you can join the audience whenever. It's like super low pressure. Let's try another one. Which of these instruments could I grab by the neck?
Can I still avoid citizenship of illegals, but grant legal residency and mitigate difficulty?
Almost out of time.
Congress can do a lot of things. Can the Supreme Court do it? I don't know.
Who picked this? The rest of you, it's time. Welcome back to the killing room. Tattoos. Create a new tattoo on my back by drawing on your device. Oh. Oh. Bring it. Right there. That's some sweet ink. Now vote for your favorite tat. The artist with the fewest votes will die. Vote already. What did we decide?
Really? You guys didn't like my heart with the arrow? You voted against my heart arrow one? Love? No? Aww.
You know, I respect my parents for balancing their serial murder and hotel management careers and still finding time to horribly scar my psyche. Oh, this is our stop. Let's keep moving. Which instrument is Kenny G best known for playing? Time's running out. Who picked this? The rest of you who are still alive, follow me. A game of telephone. I'm giving each of you a telephone, but I only have 2 phone numbers. Dial one of these numbers on your rotary phone before anyone else, or you die. The elderly are really good at this game.
Hands up if you've actually used a rotary phone in the real world. Does that mean I'm old? At this point, I feel like I need to do hands up if you've used a touch-tone phone in the real world. How many of you have used a landline? How many of you know what a landline is?
Get busy living or get busy signal dying? Yeah, you know what? That one looks better on paper. We're here. When one player is left alive, we'll go to the final round. Next question. How old is our universe? Time's almost up. Who picked this?
Tony P got it wrong? Oh no, Tony!
Come with me.
Oh no!
Time to try to save yourself with a password. Enter a real 4-letter word with your device. Don't make it easy. If someone cracks your password, you die. Now everyone else will try to crack the password. As a team, guess the password on your device. You get a clue if your guess has a letter in the right spot. If anyone figures out the password before time runs out, I will reward you all. Don't be greedy about what letters you figured out. Let everyone know. Time's almost up. I thought everyone was good at hacking passwords these days, but I guess I was wrong. Let's try another one. When was the first submarine attack?
I know this one.
Almost out of time. Who picked this? Time for consequences. Time to get out the dice. Don't worry, this one's real straightforward. The player who rolls the highest will die. But we've got some help to make this more interesting. You have an extra die that you can give to whoever you want to make their odds worse. Would you care for some dice with your dice? Time to roll. The player with the highest total dies. My money's on the player with 6 dice. Am I right? Roll the dice or something bad will happen.
Oh dear.
That can't feel great.
Yeah, that wasn't good.
Let's keep moving. What is salt and pepper?
Push it. Push it real good. Da, 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 da.
Time's almost up.
Ooh, baby, baby. Baby, baby.
Who picked this?
Is it 3 of them? Oh, okay.
Follow me. The lost art of letter writing. I'm going to dictate a message to you. Write down as much of what I say as you can. The player who writes the fewest of my words will die. You're lucky this is such a good letter, and I'm starting it now. Dear local action news team, do you take requests? I would like to see more uplifting feature stories that share positive images and less segments about the crimes that I have committed. Viewers are tired of all the sad stories I am directly responsible for. Time's up. Okay, now let me just look back at my beautiful words as and here's how you did. Yikes, one of you did real bad. This letter is not up to my standards. Thanks to the ghost for not going into the light and instead staying here just to keep playing this dumb game with us. Let's try another one. Hey, let's get our story straight when the police ask questions about this fun game tonight. What does alibi mean in Latin?
I know.
Time's running out. Who picked this?
It means elsewhere.
Time. Time to be subjected to the loser wheel.
Tony is definitely rocking it today.
Spin it. It's fun.
How did my mod get that wrong? I don't know. That's a good question.
All my money on deck.
I'm not sure if he can continue being a moderator.
Not gonna lie, that hit the spot.
You do Greek, not Latin? What's the Greek for elsewhere then?
Let's keep moving. What is not part of a classic BLT? Time's almost up. Who picked this?
Hey, we all got that one right.
I'll
Yay!
have to kill my writers. Let's try another one. Which of the following is not found in a prokaryotic cell? Almost out of time. Who picked this?
Didn't know that one. Yeah, didn't know that one.
Only a ghost got it wrong. Too easy. Ah, crap. It's checkout time and too many of you are still alive. Let's fix that. Okay, this is a game where only one person can survive, so I hope you don't mind a little water. Only one of these keys will open the lock to your tank. Pick the right key before you drown. 1, 2, that key doesn't work, pick a new key. I guess I could have given you less keys. Well, hindsight is 20/20. Glad to see you're the one to make it here alive, but will you be the one to escape? I'm going to give you a category. Venomous animals. Tap each answer that fits the category and then press submit. Time is almost up. Let's see the right answers. You move forward 1 space for each correct answer. You're a little bit closer to escaping. Oh wait, did you think it was going to be just you? Aw, that's cute. If a ghost catches up with you, they will steal your life force. Then they can escape and win the game. Here's everyone's next question. And they get a third chance to help them catch up to you. Time is almost up. Crustaceans. Launched online before 2000.
All 3, huh?
Don't fall behind. It's only darkness. Star Trek captains.
If you get this wrong, we can't hang anymore.
Time is almost up. A lot of lucky guesses.
Nabanalt, got that wrong? Yes.
Foot-specific problems. The exit is so close. Former Soviet states. Major greenhouse gases. Time is almost up.
Yeah.
You killed your friend. Better get away fast. Famous duos where one is a dog. I gotta get some harder questions. One last trap. If you want to break through that barrier, you'll need to ace this next question. And if you're still alive and want to break through, you have to get all
I don't know
K-pop
K-pop.
right.
That's not fair. Got it all wrong. Got it 100% wrong.
Another life force swap. Here comes the next question. Parts of an animal cell. Time is almost up. You have to get all the right answers to escape.
All right, come on, Kurt, you can do it.
You on the way out.
Let's go, you can do it.
Countries on the equator.
I hope. Oh, no. No, Tony wins. No, Tony wins. No. All right, that was fun. I think I'm gonna sign off for now. I'll probably be on later today with some other streaming or something, but we had a good time, didn't we? We had some fun. We had a good time. We hung out. We did some constitutional law analysis. We did some hardcore constitutional law analysis today. It'd be really interesting to see how this develops. I don't know what the Supreme Court's gonna do. I think the smart money's probably on them disagreeing in the end. I don't think the Supreme Court has the balls. Even if it's the right decision, I don't think they have the balls for it. Yeah, it would. I don't think it can get enough votes. Yeah, I don't think they have enough balls for it. We'll see. But we definitely can play later tonight. Definitely can play some more later tonight. That'd be good. Yeah. It'll be interesting to see how fast it gets to the Supreme Court. I don't think they're in a hurry to get there. So it could take a long time to get to the Supreme Court. I mean, the injunction will probably get there fast, but they're not going to pick it up on the injunction. All right, I'm going to sign off. I love you guys. I hope all's well. Stay safe out there. And I might try to go out or something and do something fun. I don't know. I'll talk to you guys later. Until later, my friends, I hope all's well. Cheers for now, my friends, and goodbye.